Good afternoon, everybody. Today is May 22nd, 2025, and today we're going to be talking about criminal enforcement of support orders, which is almost a misnomer because it's also just criminal enforcement of support, even when there's not an order. And today I have with me two delightful family law attorneys. Kristen Robinson is the immediate past chair of the family law section. And she's been a long time family law practitioner in Oakland County. She owns her own firm called Robinson and Mellon, or did I say it backwards? Mellon and Robinson. Sorry, Erica. They're both lovely ladies, so it doesn't matter which one's first. Mellon Robinson in Oakland County. And Ashley Chalut is a younger attorney in Livingston County. She is a brand new council member for the family law section and has been really trying to get involved and meeting people in the past couple of years. So she has been busy in Livingston County. I think that's where she was today. So welcome, Kristen and Ashley. I'm so happy to have you here. And I have a very special reason for having both of them because they've had some experiences that are directly relevant to this topic, which actually was the inspiration for the topic. I don't know if you want to say anything first or you want me to just start throwing out questions.
I'm fine with whatever you want to do.
Okay. So the first topic I wanted to address was what to do if a prosecutor is pursuing your client for like criminal charges, even when there's not a support order. And when I heard about this scenario, I was like, what do you mean prosecuting somebody for not supporting their child if there isn't a support order? That doesn't even make any sense. But apparently some attorneys have observed this. So this is where I'm going to, while Kristen's talking, please, if you have experiences, we would love to hear about it in the chat. Just go ahead and share if you can. No names needed, but if you could tell us the county, that might be helpful. So Kristen, I'm gonna let you start because I think it's a really important topic that maybe is recurring in other parts of the state as well.
Sure. So this particular statute came to my attention kind of in a roundabout manner. I had a client who was being pursued by the Macomb County Prosecutor's Office in an effort to serve him with a paternity action. He knew this was coming. He had already retained me before he was contacted about service. The investigator, who is an employee of the prosecutor's office, reached out to my client, making arrangements for service. He informed him he had an attorney.
And this is to serve the paternity or the paternity action.
The paternity action. Mm-hmm. I certainly would have accepted service on his behalf. The investigator continued to tell my client about the process and let him know that it was really easy. He just had to come in and sign some paperwork and he didn't need an attorney.
Wait, he had to sign, would sign some paperwork to confirm that he's
that's
biological
a good question,
father?
Right?
What is that all about?
Why is this non-attorney employee of the prosecutor's office advising a person who's identified himself as being represented by counsel? A, the investigator's not an attorney, and B, telling a defendant that he doesn't need counsel. That was problem number one. So when I was upset, I thought that, that the prosecutor's office has an obligation to follow the rules of ethics and the court rules. And so I reached out to them, and in doing so, I learned from a former prosecutor that there is a practice going on in Macomb County where the prosecutor's office is using as far as I'm concerned, little known statute under the Michigan Penal Code that has to do with disorderly persons to collect child support. Not even collect child support, to serve defendants in a paternity action. So I'm going to share my screen to show you this particular statute.
Put it in the chat as well, but just the number. So you share your screen. Yeah.
Okay. So it's MCL 750-167, and what they're relying on is this 1A that states a person is a disorderly person if the person is any of the following: a person of sufficient ability who refuses or neglects to support his or her family. So what's happening is the prosecutor is authorizing charges and requesting bench warrants from the district court. They send a letter to putative fathers telling them that they're in violation of this statute, and if they don't show up at the prosecutor's office and sign some paperwork, that there'll be a bench warrant issued for their arrest.
Well, this leads me to a whole bunch of questions.
Right.
How do they know that they're not supporting their family?
Well, and who's to say what that is if there's no establishment of paternity, and B, no support order?
Right, but there are people who, without a support order, do provide, like, maybe food or clothing or do things. How do they know that you're not doing that? And
Well,
and whose family? Apparently, it's not just children. Like, could it be your girlfriend? And what, if you have multiple girlfriends, or it could be your nieces and nephews or grandparents. I mean, what family was not defined? I looked it up.
right.
What does this apply to?
Well, that's exactly the point of this. Is really a public service announcement to everybody on this webinar, that if somebody reaches out to you and says this is happening to them, it's real and they need some help. I see it as a scare tactic. If you think about the types of people who the prosecutor's office is focusing on, they're probably people who already have some kind of criminal record. And what has come to my attention, even since we were discussing this topic, Lisa, is that it also most likely is a possible violation of the use of the lien system. So the prosecutor's office is using the lien system to find out where these people live, to send them letters. And, I don't understand why the prosecutor's office doesn't have to follow the same rules as everybody else for service.
So I have a question about, you said, so in your scenario, your client would serve a paternity action. I don't know there was ever a letter sent to that particular client. It might be a completely separate case where your client received something about failing to support family.
That's why this kind of came about in a roundabout fashion. It kind of my investigation into this had to do with the practices of the prosecutor's office with regard to getting people served and the things that their employees are telling defendants. And this second, my client was actually being served with a paternity action, which is proper, right? But it came to my attention that this is another method that the prosecutor's office is using when they don't have information about the defendant. So what happens is, as most of you on this call probably know, the mother in the case is seeking some kind of state assistance. In many counties, and I think this might vary from county to county, but in many counties, the prosecutor's office is representing the Michigan Department of Health and Human Services. So they only have the information that has been provided by the mother. If the mother has a bad address for the putative father or no address for the putative father, the prosecutor would have to go through regular means to get an order for alternate service or do some investigating to find out where this person lives. The end round to that is accessing the lien system, seeing if this person is in there, finding out their most recent address, and sending them, in my opinion, a scary letter, threatening letter that says, do this or we're going to issue a warrant for your arrest. I mean, that's just shocking to me that this is going on. So I
I
learned of this.
thought, yeah, okay, I'll let you
I
finish, but I want to hear, I believe this is happening in other parts of the state because I think we started talking about it and other
well, I-
people had said the same thing that they experienced a completely different part of the state.
exactly. So I was thinking, okay, as a family law section, what can we do about this? I brought it to the attention of the Family Law Council. And at that particular council meeting, there were several people who piped in and said, oh, no, they do that in my county. Oh, yeah, they do that in my county. And so it may very well be a practice that is used. And I think, Ashley, you were familiar with this practice as well in a different part of the state.
Yes, I've seen it in other parts of the state. It's common in rural counties where we're trying to get those people in to make sure that they're paying the support issue. But what's interesting is that this is a district court action. It's a misdemeanor to have a disorderly person under this statute, which puts this into a district court case rather than leaving it at the circuit court where the circuit court has exclusive authority over the support. And I think that's also a problem here because at what point are we allowing procedurally a district court to make decisions that are under the control and authority of a circuit court, particularly if there's support actions involved and under the Summary Support Act, that should all be proceeding through the circuit court, not through the district court. And so it is, in essence, also consideration of a violation of how we award jurisdiction and authority over these issues. And in terms of like this happening, if you are an unsuspecting person and you don't have the money to have an attorney, this is terrifying. You don't know what to do. And so they are stuck in this position of trying to defend against a bench warrant that they think is actually going to happen when really they just need to be served the paperwork. And it's almost a misrepresentation for these people, and it's unfair practice.
Right, it's very worrisome, and I, have been practicing for a long time and was unaware of this, and I was thinking back to I can't exactly recall, but I can imagine that somebody contacted me and told me this was happening to them, and I dismissed it as that they don't know what they're talking about because this would never happen. And so I think everybody should be aware that if they hear this type of practice, it very well may be true in the person who's at the receiving end of these letters, threatening bench warrants, they need some assistance.
And I mean, your client had an attorney and he told the employee that he had an attorney, but just think about all the people who are like receiving something or trying to figure out something and they don't have an attorney yet. Doesn't mean they're not going to have an attorney.
Especially if they are, I mean, if they do have a criminal background and maybe they're on probation and they get a letter that's saying that they're going to be a bench warrant's going to be issued. I mean, that could be a violation of their probation. I mean, there are all kinds of, domino effect things can happen. And none of it is how the statutes are set up. To Ashley's point, the circuit court has exclusive jurisdiction over these matters. So,
Well, two things. First, Steve asked if we have heard of actually a person being prosecuted where charges were filed, or are they just threatening? Which threatening charges is also a problem. Do we know of any? Have we heard of any stories where the charges were actually filed?
So no, I am not aware of any. I mean, I just find it very hard to believe that a district court judge would hear the case.
Can you throw up the statute again?
Sure.
Because it talks about disorderly person and like it seems like where did this come from? Like that line about not supporting your family being it makes you a disorderly person. It just seems like it's a
Right.
let's
Right.
look at the other things. Oh, being a prostitute, being a window peeper, engaging in an illegal occupation or business, being intoxicated in a public place, engaging in indecent or obscene conduct, being a vagrant. Like the things that are on that list belong there, except the first thing.
Right.
And then notice that a mother breastfeeding in public does not qualify. So they do have an exception for that. One thing that came out of our meeting about this the other day was the penalties. So this is a district court proceeding, right? It's a misdemeanor, but according to MCL 750168, the penalty for the first offense is imprisonment of not more than 90 days or a fine of not more than $500 or both. So could be a pretty severe penalty. And then under 167 sub 2, it has the penalties if it's multiple, right? Multiple incidents. If a person's already been convicted and they have a second offense or third offense. What does it say? Sorry.
Then it becomes effective as the second or third offender situation under 168, which is identified here as 168D, but for the purposes of discussion, it is ultimately an elevating situation where it could result in a felony offense for some of.
Okay. Right. At the second or third. I mean, the fact that we don't even know what family is and what is, for purposes of this statute, we don't know what support is and what family is. Like, we know what it means in the context of a family division case in the circuit court. But I think it's like very vague here. And I would love to see a case where this could be challenged
Right.
for constitutional grounds.
It's really interesting because you felony support, like you non-payment of support in the felony sense for the criminal allegations with the AG's office. What would they do is they charge the felony non-support, and oftentimes one of the plea deals we are offered is to plead to the misdemeanor disorderly person non-support action.
Oh,
but there
it's
isn't
like
a jury.
lesser offense. Yeah,
it's a lesser offense, but we don't have a jury instruction for this particular offense, so there's nothing to define what any of those things mean. The statute itself doesn't define any of those things, and then it creates this problem that we are in essence, if someone reports this as a crime, they could proceed under that statute for non-support. It's essentially an argument of abandonment for families. And at what point does it become abandonment? And what point are we supporting a family, or are we supporting just the children or the spouse? What are those positions?
The siblings or the cousins?
Mm-hmm.
Right.
so this was one scenario where parents or potential parents who don't have a support order against them might be prosecuted or pursued by the criminal prosecution for not support. Is there, I think we maybe talked about default situations. I don't know. I suppose let's talk about default. I know, Ashley, you had some scenarios that we discussed about when there's a default because who knows why they're defaulted. I mean, maybe they weren't properly served, but in a DS support case or in a DP paternity case, and the party doesn't show up, so they get defaulted, and then there's a support order and
eventually a felony non-support case, because the amount gets so great that these people end up charged, and they're like, well, it's not even my kid. And at that point, by the time it gets to the point where it's at the felony level, the amount is so great and they've lost their ability to challenge that default because, well, what's good cause? And at that same time, if I go to the court and I say, well, good cause is that I was never served and it's been 10 years, how do I prove non-service? How do you prove? Because a lot of the people that you would have used to prove that allegation to say, hey, I actually was supporting them appropriately or not supporting them appropriately, you lose out on that ability to demonstrate all of those facts before the court. So at what point are you stuck in this endless loop? And then the other problem becomes with situations like that, where they are giving money to the parent, but they're not paying it through MIDSU. Then they're racking up arrears and they think that they're fine, that they're following the orders that they had to follow. They're paying the support, but they're paying it directly. That can also lead to these people getting felony non-support actions. And then we're stuck in the endless loop of having to deal with a situation where you weren't found to be the father because you didn't contest paternity, or you were found to be the father because you didn't show up. And then you have a support order that's entered by default based off of information provided by the other parent. And then you are stuck in a position where you never challenged that order. You could rack up child support that's not even proper under the Michigan child support formula because it's based off of figurative numbers that were put forward by one party and not the other. And then
I get up my court rules. I'm gonna look up something, but I have a question. Why, at what point does the friend of court get involved? Like, wouldn't they be involved or are they being cut out of the process? when maybe they shouldn't be.
Should be. Well, the beginning, I mean, this wonky district court warrant thing, they're not involved at all. But of the front of the court act states that the front of the court has powers to enforce, and they should be utilizing all of those powers before there's a felony non-support case. And those powers to enforce are pretty significant. We have a, let me see. So, you know, the front of the court, of course, we know can do income withholding. They can do a tax refund.
Garnishment.
Mhm. They can, of course, the front of the court also has the power to show cause a non-payer and issue a bench warrant, which is a different process than through the prosecutor's office.
Can you repeat the statutory provision you're looking at? Didn't write it down. This is the front of court powers, right?
Yeah, it's in the front of the court act,
Correct.
which I just see. Let me look that up and I will put it in the chat. And I lost it at my fingertips.
Okay.
The front of the court can lien real property and personal property and financial assets. The front of the court can do a driver's license suspension. They can report an arrearage to the credit reporting agencies. They can put a hold on a parent's ability to use their passport. They can, as an extension of support, there's also medical support. They can issue a medical support order. The front of the court can issue a qualified domestic relations order to access a retirement account for a qualified plan or an eligible plan, so a quadro or an ADRO, to collect current support or past due support.
Have we ever seen that? And I mean, it's in the statute, but that's like what little involvement I have with quadros and edros, you know, coming on appeals, and you know, they're.
I was successful in having a judge. The only money that the person had who had a huge arrearage was in a 401k, and the court issued a quadro where the alternate payee was the mother of the child, and the support was paid through a quadro. So, and I think that's oftentimes overlooked. And then finally, the front of the court can refer the case to the county prosecutor for criminal or felony charges. So, and so the front of the court is generally speaking, uses all of their resources to collect support because that's their job. And then when it gets to the point where they are not successful, then they refer the case to the county prosecutor. And I think, depending on, in each county, it's a little different. Sometimes those matters are referred to the Attorney General's office.
Yeah, so like Livingston County, all of those matters are referred to the Attorney General's office for us. It's very rare that we have the actual prosecutor's office on the other side in support matters.
So, Ashley, earlier you mentioned the fact that hey, why isn't this in circuit court, right? And I think we were talking about some statutory provisions. I don't know if you've written them down, but I have them if you don't, that really to us indicate that if it's a family law matter, it has, and this we feel is a family law matter, has to be in front of the circuit court. Did you want to share those statutes really quickly, or do you want me to?
I think I still have those statutes from when we talked the other day, but essentially the powers of the circuit court are exclusive authority over support matters under MCL 722.720. And then under MCL 600.1021, circuit court jurisdiction includes support. And that is the MCL 600, which, hang on, let me just pull it.
That's the Revised Judicature Act, I think.
Yes, that particular statute is the one that grants continuing authority. It's the statute that we use quite often without even realizing that we're using it. So if you look at it here, my help the share button. So specifically, as it is listed out here in the statute, what's important is that cases involving child support under the Revised Uniform Reciprocal Enforcement of Support Act are designated to the authority of the circuit court. It's not something that's necessarily afforded to the district court. It also covers all of the cases relating to the Support Act and anything within the Support and Parenting Time Enforcement Act and the Interstate with Income Withholding Act. So my position is when we're looking at a support issue and a non-payment of support, it falls under the jurisdictional authority of the circuit court to make those decisions because it's an authority that we've awarded specifically to the circuit court. So when we're talking about charging for disorderly person, is that really an accurate way that we can charge that offense? And is it even something that the district court can rule on at that point? Is it the one time where we have a conflict in the statutes where we're affording authority over a misdemeanor to the circuit court and improperly filing in a district court case? It's an interesting question.
The other thing with the default scenario that we talked about, well, two things. I pulled out the court rules, and I think the example that Ashley gave, the support order was entered years and years ago. And indeed, under MCR 2612B, if you're not personally served, you're not personally notified of the decision, you only have a year after the final judgment to come into court and say, explain, show your reason justifying relief from the judgment. So if you haven't been, if it takes them a long time for, if it takes a long time for you to find out that there actually is this order that is accruing a support against you, it's going to be too late to use that court rule, unfortunately. And I had another question about when we're in a default scenario, you know, the friend of court goes through this whole process of determining what the income is, right, of both parties, so it can decide what support is needed. I'm assuming the courts use some sort of calculator, just like private attorneys do. How do they come up with the number if they only have the one parent in the room?
They rely on the one parent.
Do they question how that the one parent knows, like, what the income is, or, you know, how do they have any like assurances or feel, you know, confident in the accuracy of the numbers?
In a default, they're relying on that person's knowledge, that one person who made the complaint. So actually, an excellent example is I actually just took on a new support action. Mom filed for child support in that case. I know that the child support calculation is incorrect merely by looking at the complaint. She's alleging approximately $1,827 in childcare expenses, when I know that her childcare expenses per week are $197.25. So it's a bit of a drastic difference in the number, and she has allegedly provided documents to support those childcare costs. But she also has my client imputed at an income of like $2,300 and something per month. My client's unemployed. And so even if he was earning minimum wage, that mathematical calculation doesn't really add up. And I don't know where they got that number. And so one of the issues with a default situation is that mother fills out a bunch of paperwork, or father fills out a bunch of paperwork, submits it in, they make a complaint for support. If there's never a response to that complaint for support, they're going to use the numbers that they've been provided with some documentation if it is provided to them. And then you're entering a support order that isn't necessarily accurate. Right now, my client is alleging to be ordered, or likely to be ordered, to pay $1,072 a month in support. And I know that that math is not correct. Like, I know because I recognize that that's a drastic support amount. But if you're the person who is in a default situation, you never contested that order, what do you do in that point? You have to come back and you have to try to modify support to fit it. But sometimes you don't even know that it's been entered against you until it gets to $17,000 in arrears and your child is 14. And how do you modify or change that? Because retroactive modification is not applicable.
One last question before we switch topics. When a parent, and let's just use the scenario of a mother, applies for government assistance, to be on food stamps or welfare, whatever the case is, how I gather that the process, like it's kind of like out of her hands at that point. The government is going to pursue paternity and support before they authorize, her receiving government assistance. So I'm just curious if either one of you can share anything about how that process works when the other party is just, all they did was apply for government assistance and, I indicate that they're not receiving support.
I have a couple of those right now too. I like paternity. It's kind of my favorite thing. So essentially what happens if mom is applying for assistance from the state, DHHS will send over for the petition to the prosecutor's office, and actually DHHS will get involved in situations where dad is receiving public assistance and mom is applying for support from that public assistance, which is actually what's going on in one of my files right now. But when there is public assistance involvement under the 1201D form that we all fill out when we file cases, the power of DHHS allows them to say, hey, you're receiving public assistance. We're going to seek support against the non-paying parent, the non-supporting parent, and we will, in essence, collect some of that support to make sure that our public assistance is paid back and to make sure we're awarding you appropriate public assistance. When they do that process, they have to name a father. If they do not name a father, then there is a whole bunch of statutes that apply to what happens next, but they have to name a father. And if they don't name that father, then they have to try to come up with who the father is, and then they start a paternity action.
Wait. So, I mean, there are scenarios where the mother legitimately may not know who the father is.
When mother doesn't know who the father
or
is,
even potential father, like potentially even have names of who the potential fathers might be.
and that's a little bit different than it would be if she has a suspicion of who it could be.
Okay.
If she suspects, they're going to take those names and they're going to say, under the Paternity Act, who do you think is most likely around the approximate time of conception of this child to be the father? And then they will go one by one through the list of people to figure out who the father of that child is. Under the Genetic Testing Act and Paternity Act, all of that kind of stuff. They all kind of operate together. And then if that father is found and determined, then it proceeds down a order of filiation, at which point support, parenting time, and custody are ordered through the process of entering an order of filiation. And that, in essence, is supposed to operate correctly. Then if mother doesn't name a father, it becomes a little bit different. And I haven't actually seen the situation of what they do if mom can't name a father for DHHS's purposes. But if they're not sure, that putative father also has the ability to come back and say, hey, no, I believe I'm the father of this child. I want to take it. I want to have custody and parenting time, and I want to have support. And then they open the door under the Paternity Act for all of those past expenses that were collected under Medicaid assistance to be assessed to them as part of the cost of arrearages and support issues.
So hypothetically, a man who just found out that, oh, wait, this woman had a baby, I think I might be the father. Let's just say it was 3 years before, will all of a sudden be on the hook for 3 years of past support?
Potentially all of the past support or cost of cost of birth.
Yeah.
And the statute affords the opportunity for that to be collected through that putative father. And it has to be ordered and assessed by the court in that act.
So
Kristen.
I just would this is just an example, and it was, relayed to me by a person the mother who was going through this. And her experience was that and I don't know what county it was, but it was in the Detroit metro area. I don't recall, but it was if you don't name a father, you will not receive services. Period.
Mm-hmm.
So go turn around out the door unless you name a father. And so, that goes back to what are the procedures and processes at these places who are handling, and places like Wayne County, for instance. I mean, the amount of these types of cases they have are, huge. I mean, I think we talked about the numbers when we had our meeting.
14,000 in 2023 for support and paternity actions.
Right. So,
For Wayne County alone?
yeah, yeah.
Alone.
It's a high volume, yeah.
So in any event, you know, also remember the people that are helping the mothers who are coming in with these issues, they're not lawyers. They're intake people, you know, they're admin people, they may be friend of the court staff, but they're not lawyers. So, and I think lots of these people are probably giving legal advice, which is a problem. So I do have the, with regard
Okay.
to the friend of the court enforcement statutes, they start at MCL 552.623, and they go through the 625s, and each one is each subsequent statute in order describes a different power of the friend of the court for collecting on an arrearage.
And for those people who don't know, after 2 months of non-paying periodic support, if there's not payments or a payment plan or some form of process, they can actually start placing the liens. So they can start putting it into the child support lien network at that point in time, as long as they've gone through other steps to comply with enforcement beforehand.
And, you know, I had a client once who, what finally got him to pay his arrearage is they revoked his hunting license or wouldn't allow him to get a hunting license. So all of these other steps didn't get him to do what he needed to do, but the revoking of a hunting license by the front of the court was what motivated him to pay his support. So it's, you know, those are very broad powers, I think, to get arrearages collected.
So sort of slightly switching gears, because we've been talking about paternity orders already, but when you or your client want to challenge a support order because on the grounds that the paternity order, which was obviously a necessary prerequisite to the person owing support, was improper or invalid. One thing I think we maybe already mentioned here, I think Ashley, you said it already, but I just want to repeat it here, is that when the Attorney General goes after a person for felony non-support, in that non-support criminal case, the man, for example, can't challenge paternity. I think you said that earlier today.
Correct. So when you have a felony non-support case, the proper place to challenge that paternity is actually in the DS or DP action. You cannot do the challenge of paternity through the criminal action. It's, in essence, separation of the family court from the criminal court. But enforcement of that criminal proceeding can start occurring or be in the process of occurring while you are challenging that paternity or support order. So it creates this, I think I want to say vacuum, but I don't know that that's the right term. It creates this unique situation where if you didn't know that was your child, you ended up getting served a warrant and you got arrested, and then you have a unique challenge to paternity or support, and they're still proceeding with enforcement proceedings. You're kind of in that weird space where you are stuck with trying to pay a support order that may not necessarily be proper.
Right. And so what I think one idea that you had yesterday, Ashley, was pursuing a ROPA action. Do you want to talk about that? Either one of you want to talk about that for a minute?
Go ahead.
We could talk about it as ROPA. So in situations where you know that there's an improper paternity order, you can seek a ROPA action to have either paternity revoked of that child, or you can try to seek a ROPA action or like a affidavit of parentage action to establish paternity of a child. So there are different ways to kind of go about it. The paternity, ROPA, and affidavit of parentage, acknowledgement of parentage statutes are all intertwined with each other enough that if you ask for paternity act, it reflects back to the genetic parentage statute. And if you take an action under ROPA, it also refers back to the genetic parentage statute. So when you have that improper support order and you are stuck in this loop of a client says, I don't know that that's my child, your best chance of trying to get rid of that is to intertwine those acts together to be able to set that paternity order aside or to challenge that paternity order. If there was a default, there may be that, yes, while there was a 1-year period to do so, there also is, under the operation of the court rule, good cause has to be demonstrated. And if a client has good cause to demonstrate that they didn't know, take the chance. Because
Right.
why would we want to collect from someone if we don't have a parent?
Right.
Right.
And
other-
the revocation of parentage, isn't there like, I didn't pull out that statute, but I think it's the child can't be more than 3 years old unless it's in the
Correct.
context of divorce case, which none of these examples are would be a divorce case context, right? So
Both revocation of parentage and so overturning an affidavit of parentage is 1 year. Revocation of parentage is within the first 3 years of the child's birth, if you can get there. And under the acknowledgement of parentage, if you're revoking your acknowledgement of parentage, you must demonstrate good cause for why it exceeds more than 1 year from when you sign that affidavit. So there is a little bit.
There is a mechanism.
Yes.
But okay. Kristen, you're about to say something.
I was just gonna say that there's another thing that I think is overlooked, based on our conversation. That there's a statute and a court rule that require that an order affiliation has a child support amount. Period.
That is an excellent point. Do you mind pulling up MCL 722.717? I've actually been thinking about that a lot. Because I previously was thinking, well, if you don't have a support order in an order affiliation, it just means you don't have a final order yet, so you don't have an appeal by right. But I have been studying that statute a little bit, and I think you're right, Kristen. It's an order affiliation that only has establishment of paternity, but does not include child support, is an invalid order affiliation.
Right.
Go ahead and you can point out the
So,
language.
Sub 2.
Well, first of all, sub 1, in an action, the court must enter an order affiliation declaring paternity and providing for support.
Right.
So there's 2 things that are required, and then go ahead to sub 2.
And then sub 2 states an order affiliation under sub 1 must specify the sum to be paid weekly or otherwise as prescribed in section 5 of the Support and Parenting Time Enforcement Act. There's no if, there's no can, there's no may. It must specify the sum.
So if it only does one thing, if it only says this guy's the father because of the DNA testing, but doesn't do anything else, then
it's an insufficient, invalid order, which ironically, Lisa, I'm scheduled to argue that on June 16th in Genesee County.
So do you file a motion what would the motion be? A motion to declare something invalid, a motion, because a judgment is void, that is not subject to the 1 year. Oh yeah, the judgment is void. It's not subject to the 1 year provision.
Yes. So in that case in particular, we did genetic testing. I revoked the acknowledgement of parentage because we had concerns about parentage in that case. Mom resides here, dad lives in another state, dad's been gone for quite a period of time. And mom is asserting that that is his child. Our argument to the court at that point in time was, we want to make sure this is his child. The case has since been transferred to a different judge, and now the court is asking for an order affiliation. And my position is order affiliation must include custody, parenting time, and support by operation of MCL 722.717. And so what I actually have before the court is a motion for entry of an order that identifies the order affiliation, identifying him as the father, and sets it so that custody, parenting time, and support are addressed in a subsequent order, but the parties must be ordered to mediation to resolve the pending dispute. I have tried to work it out with opposing counsel. I've sent the provisions to them. I said, we can't enter an order without agreeing on custody, parenting time, and support. I have tried multiple times. The court's asking me where the order affiliation is. I filed a motion because I think it has to be argued to the court. I can't enter an order of affiliation. I think it's malpractice for me to enter an order of affiliation that doesn't resolve the issues that the court must address under that statute. And so, in essence, I have a motion for entry of an order that seeks to establish custody and parenting time and support, as well as a motion to order us to mediation because that case hasn't been mediated and it should be mediated. It should go through the regular process of a custody case once genetic parentage was found.
Kristen, didn't you find a court rule that is
Yeah.
also kind of ties into that
Yeah,
statute?
MCR 3.211D states that all provisions under the paternity order, like support, has to be in the support order. So an order of affiliation is a paternity order, and it has to have all the same provisions that are required by court rule. So we have a statute and a court rule that allow you to set aside an order of affiliation that would, it's like a, rather than attacking the affidavit of parentage and all of those statutes, this is actually attacking the order itself, which is procedural in nature.
And I was reading the wrong part. I was like, I don't see what you're talking about. The subsection D about uniform support orders, it's under D2, which says no judgment order concerning a minor or spouse shall be entered unless either the final judgment incorporates by reference a uniform support order, or the final judgment or order states that no uniform support order is required because support is reserved or spousal support is not ordered. Can you reserve child support? I don't know that you can do that. That's referring to spousal support, right?
I think so, yeah. I think that just practically speaking, I think that if you're challenging an older order, you're likely to find you're more likely to find that all of these provisions aren't in there. But I feel like now most judges are very cognizant of the rules regarding the entry of a uniform child support order contemporaneously with the order affiliation. But I think that's more recent. I think that if you're looking at an older order, and depending on which county you're in, I think you could potentially find those orders affiliation that don't include the child support and would be grounds to set that aside.
Trying to figure out when this provision came about. There's a staff amendment from 2006 that requires support orders to be entered on a standard form. That seems to not really be relevant. Okay, well, that is, I think, fascinating. I know regarding cases where there's an invalid paternity order. I know, Ashley, you had one of those in the trial court. My office, I think it was Jennifer Alberts at my office, did the appeal. There's a published decision, but because I wasn't personally involved with the case, Ashley and Jennifer were. I was going to let Ashley talk about it for a minute because I think it's just another scenario that's relevant to this topic about there being an invalid paternity order because of various things that happen in the case. We know it by King, but I think I don't remember the whole case name right now. What is it?
So it's Lyra v. King, for those of you who haven't had an opportunity.
Lyra?
Yep, Lyra. I strongly recommend it. It's a great case, both about UIFSA and UCCJEA and all of that stuff. But the primary issue that we had in Lyra v. King is she, essentially, mom left for the country of Brazil. The Hague Convention is involved in the case. Hague Convention issues an order that basically says paternity has not been established and kind of like kicks the can down the road. Mom has the child in Brazil right now. Mom files an action for support, and a whole bunch of other things are happening in the interim. Client comes to the office and says, I don't know that it's my child. I believe it's my child, but I don't know. We file a corresponding action for paternity to run collaterally with the support action. In the support action, I had requested genetic testing. I said, just give me a genetic test and we'll agree to support if it is his child. It was rejected. And so every single time we went
Wait,
to court,
your request to have genetic testing was rejected?
yeah, by the prosecutor, he was like
Oh,
not willing
okay.
to agree to it. So I said to the court, every single time that we were there on a hearing, that paternity in Brazil does not mean paternity is established here in the state of Michigan.
And when you
Because
say paternity in Brazil, it was just that he was named on the birth certificate in Brazil,
yes,
which does not establish paternity in Michigan. If it were a Michigan case, that does not establish paternity.
correct. And in a Michigan case, and this comes back to UCCJEA and EWIFSA, under both of those acts, as the responding tribunal, we are the one who sets the rules for how that is established. So we are the responding tribunal. We set the rules. Paternity needs to be established under Michigan law, not Brazil law. And even then, because we are challenging paternity, we have the ability to continue to challenge that paternity. And I just kept reiterating to the court, Your Honor, we're still challenging paternity of this child. We're still challenging paternity. The court accepted the prosecutor's argument that being on a birth certificate in Brazil is enough to establish paternity. So we finished the hearing. I contacted my client and said, you need to call and appeal this decision. Essentially, the Court of Appeals has agreed that paternity needs to be established. We need to have a hearing or some other thing needs to occur to establish if paternity has been determined either by the country of Brazil or the US. Actually, my brief on this is due next week. Because essentially my position is it has to be established here as it would be under the state of Michigan rules. Being on a birth certificate isn't enough. Applying for a passport for that child, that's not enough under Michigan law. He has to either sign the affidavit of parentage, he has to acknowledge that paternity, and even if he signs the affidavit of parentage, he still has the right to revoke that affidavit of parentage for 1 year of signing. The child at the time when he brought this action was 9 months old. We had the ability to continue to challenge paternity at that point, and we still have that issue pending because service in Brazil is rather difficult. But it is something that is relevant because the minute that judge had determined paternity was sufficient in Brazil, she also signed a child support order that in essence is invalid, which has now been abated while we figure everything else out. But now my client has paid support for all of that time while we were pending appeal. And he now has paid all of this money for a support order that was in essence invalid because no one has established paternity.
Because the mom's in another country, well, even if she were in Michigan, I mean, he's never going to see that money again.
Exactly. And now he's lost all of that.
What's the prosecutor's rationale for not allowing a genetic test?
Yeah.
Or not
That's
a genetic test? That seems like the simplest way to settle the matter.
Ashley, what did you say?
I think so too. It's a great question. He still hasn't answered me about that.
I mean, I can't even think of a reason why you wouldn't do that.
I think part of it is the difficulty of presenting mother and child for genetic testing, but there is actually an operation of the Paternity and Genetic Parentage Acts that allows for testing of individuals who do not reside in the United States. And that is one of the points of argument for my brief, because essentially I think genetic paternity testing would resolve all of this problem and we can in essence move forward from there.
And why would the courts in Michigan want to have their jurisdiction invoked to, involve the Michigan courts when there's a chance that the person's not even the biological father? It's one thing if he is, right?
Sure.
Totally different.
It's always funny because I've been talking over this with my mentor a lot. And I said, the problem about this case is this enables people who live in other countries to just declare someone as someone else's child. There's no way for them to contest it if this is the way that this is going to stand. And we're in essence creating a procedural hole, a public policy issue that needs to be addressed, because ultimately, if we can't fix that, we're saddling people to paying child support for a child that we don't know is theirs in another country that we can't bring to this court to be able to test and make sure that it's theirs.
Wow. We're almost out of time. So I just had one other small topic. I just wanted your feedback from both of you. The issue is, when there's a criminal enforcement of a felony non-support, right? And the question is, one, if somebody is facing charges for felony non-support, should they hire a criminal attorney or a family law attorney?
So I say, and we might get different answers on this panel, but I always have my clients engage the services of a criminal attorney because I don't do that. And I recognize, I know a little bit, but I think that there are some nuances that it's important. Now I consult with and as needed with regard to the, arrearage and payment and even negotiations with the prosecutor. But I think for, especially if there's a trial, I think my personal policy is to have my client engage this criminal attorney.
Ashley?
My position is to hire an attorney who does both. But I also think you need to hire someone who, if you are challenging the underlying issue of that support order, you're going to need to engage a family law
Family
attorney.
law attorney, right?
Particularly
You can't do that in the criminal case. You can't challenge the
Right.
basis for the support order, the basis of the attorney order. So your criminal defense attorney is going to have to represent you in the criminal case while you engage separately, potentially, if there's not one person that does both, family law attorney to pursue maybe other relief in the family division courts, hoping that maybe one decision will make the other one go away, right?
Exactly. I practice both. So like I like support cases. I mean, I like to also be paid, but I like support cases largely just because the theory behind it is quite fun for me, and I don't mind arguing with AGA Brenner. So it's one of those things where we are kind of trying to combat an issue on both fronts. And in rural counties, you're more likely to find an attorney who does both, who practices both criminal and family law. And so you can take that and use that to your advantage because they can help you with the family law issue as well. But I think ultimately you're going to want a criminal attorney for the criminal issue and a family law attorney for the family law issue.
One last question. If there's a felony non-support for less than $25,000 owed, does that still go, does it go to district court
Goes to circuit court.
because it has to do with non-support?
Yes.
Right. Circuit court has exclusive jurisdiction over all things family.
Which is why it's confusing that where going full circle, 750167, why is that a misdemeanor court if it's for failing to support your family?
Exactly.
Right, exactly.
Any last words? We're just about to wrap it up.
Nope, I think we're good.
Okay. Well, thank you both, Kristen and Ashley. This was a lot of fun, and I actually took a lot of notes. I think I'm going to be using some of it in a brief very soon. So the timing turned out to be even better than I expected. Y'all have a great day. I'm going to start recording now.